My name is Destiny Noble, and I'm a student at the University of Edinburgh, and I'm completing a LLM in medical law and ethics. Since 1991, the court has assumed inherent jurisdiction to make decisions on the medical treatment of children in certain circumstances. This was first affirmed in the case of Ree J. Since then, extensive jurisprudence has developed and reinforced the best interest test as a means for guiding court decisions in cases where parents and healthcare professionals disagree. The best interest test aims to protect the welfare and interests of the child when deciding the most appropriate course of action regarding their medical treatment. The test takes into account the views of the child, healthcare professionals, parents, and any other relevant parties. It considers what is medically indicated, the cultural or religious values of their child and their family, and any other information that the court deems relevant. The court has to balance all of these conflicting considerations to determine what should be done. Despite the sustained use of the test, recent high-profile media cases, such as Charlie Gard and Alfie Evans, have sparked live questions about whether the test is fit for purpose. In both cases of Charlie Gard and Alfie Evans, the children had incurable conditions, and there was significant disagreement between the parents and doctors as to an appropriate course of treatment. In the case of Charlie Gard, Charlie had mitochondrial DNA depletion syndrome, which caused brain damage and muscle failure. His parents wanted to take him to the United States for experimental treatment, but doctors disagreed. In the case of Alfie Evans, Alfie had a neurodegenerative condition, and the hospital wanted to withdraw his life support, contrary to the wishes of his parents. Both of these cases escalated into widespread media disputes, and doctors and parents were pitted against one another while their child's needs were effectively put on hold. These recent cases emphasize that the best interest test with regard to the care of children should be reformed. First, Iman is going to highlight a number of key issues with a practical application of the test, namely that its subjectivity results in inconsistent outcomes and leaves cases susceptible to judicial bias. The judicial over-reliance on medical opinion is unduly paternalistic, and we argue that the test fails to appreciate the child as embedded within social and familial relationships. Secondly, Ruby will argue that the courtroom is an entirely unsuitable forum for decisions of this kind. Involving the court system is a costly and time-consuming process. It unnecessarily drains NHS resources that could otherwise be put towards caring for patients. In addition, the lengthy court process prolongs the suffering of children. The public setting of the courts is inappropriate for the personal and relationally complex decisions that are being made, and the resulting media involvement fuels unwarranted and harmful public opinion and pressure. The court setting is inherently adversarial, and it puts parents and medical professionals in opposition to each other rather than encouraging a collaborative approach. Overall, the court setting has a detrimental impact on all parties involved and can damage the wider relationship between the public and healthcare professionals. So lastly, we will make two proposals for reform. First, we'll recommend an alternative method of dispute resolution between doctors and parents. We recommend a model that's based on consensus building, cooperation, and dialogue, rather than a best interest test. If mediation in this manner fails, we recommend that instead of defaulting to the courts, the case should be referred to an in-house ethics committee for decision. The best interest test is supposed to safeguard the welfare and the interests of the child, but in its current state, it's not fit for purpose, and so it must be reformed. My colleague Iman will now address the issues with the test in terms of its practical application.
So my name is Iman, and I'm also on the Medical Law and Ethics LLM at the University of Edinburgh. So as Destiny has mentioned, the best interest test has encountered some practical and legal challenges in its application, which when properly assessed, highlights its inadequacy and need for reform for the following reasons. Firstly, the inherently subjective nature of the test creates issues in consistency and predictability. Secondly, the judicial body is overly reliant on medical opinion, reducing the best interest test to doctor knows best when making decisions. And thirdly, the best interest of a child should encompass more than just the child's health, but it often fails to adequately account for the socially embedded nature of familial relations. So firstly, and most concerningly, the best interest test, prima facie, an objective test, is in reality subjective. The broad scope of the test renders it vulnerable to the idiosyncrasies of individual judges. This has been evidenced in practice, for instance in RECE and in an NHS Trust and MB, two cases where essentially identical sets of facts, resulting in diverging outcomes, both pitched as having been in the best interest of the relevant child. Children from similar familial and cultural backgrounds, presenting with similar medical conditions and undergoing the same level of ventilation, had their best interest interpreted differently. In one case, the child's treatment was continued, and in another, it ceased in the name of futility. The test is so fluid and broad that it is open to the judge to manipulate the outcome and respond intuitively under the guise of a principled approach. The test gives the judge a lot of power to decide what is relevant and reach a decision accordingly. This amount of power to determine those interests should not be left to a sole decision maker. Secondly, there is an identifiable tendency of the judiciary to defer to medical opinion in best interest cases. This reduces best interest to medical interests, making it a paternalistic decision. Confirmation bias sees judges sway towards healthcare practitioners whose thoughts they feel are more aligned with their own. Individuals are unique, and their ailments unique to them. Their relationships differ from one another, along with multiple other factors that must be taken into account aside from the medical opinion of healthcare practitioners. The recent cases of Charlie Gard, Alfie Evans, and Isaiah Hastrup are but a few examples of how often the courts side with healthcare practitioners rather than parents. Moreover, decisions made by healthcare practitioners and guidance from the General Medical Council, the Royal Colleges, and other self-regulating bodies is made on the basis of avoiding liability and not falling foul of judges. These are not judicial guidelines, but these are then relied upon by judges to affirm their decisions. For example, in Bolton NHS Foundation Trust and C, the judge's ruling affirmed the self-governing guidance for healthcare practitioners from the Royal College. It reduces the best interest determination to a conversation between professional bodies and the judiciary and excludes the parents. Finally, the best interest test requires a comprehensive approach, and in light of this, the overly individualistic nature of the test and its ability to overlook the familial interests of the child becomes evident. Although we cannot aspire to ever truly know what the child would want, it is generally accepted that there is a correlation in behavior based on the views, culture, and upbringing of the parents, and as such, they would be best placed to represent the child's potential views when making decisions which reflect what is best for them. Often after the child, the persons most affected by the outcomes of the child's care are their parents. It is therefore necessary to ensure that those who are most affected and impacted by the decisions made have a say. Equally, children cannot be considered in this individualistic way, as they are embedded within the family unit, and the importance of familial interest should not be ignored. Overall, best interest is supposed to encompass much more than just medical opinion, including the emotional state of the child and overall welfare. Assigning the limits for what is relevant falls down to the judge, which often comes down to medical opinion. This fails to give adequate weight to the parents' opinions and the socially embedded nature of the child. Clearly, the best interest test is not fit for purpose due to its challenges in its practical application and should be reformed.
So my name's Ruby, and I'm also studying on the LLM for medical law and ethics, and I also work for the NHS myself. I'm going to talk a bit about the issue of the court setting. The other side may tell you that the best interest test is there to give the best outcome for the child. However, let me tell you what the papers say about the court battles that surround the care of Alfie Evans and Charlie Gard. Conflict, bitter, turmoil, no winners, the child lost in the middle. This is what the court system brings. This is a situation where a child's life is at stake, but instead they become a point of law to be argued over. The parents become objects of public scrutiny, and the doctors are branded murderers. This clearly shows that the court system is wholly inadequate to solve the problem of what is best for the child, and that the entire setup of the best interest test should be changed. Firstly, it's a question of resources. The Alfie Evans case cost the NHS nearly £500,000. This money could have been spent caring for the patients most in need. Aside from the question of cost, the court system takes time. Indeed, the Charlie Gard case, from the first application to the point the parents decided not to pursue it, took over a year, with multiple petitions, appeals, and hearings during that time. The intricacies of the legal system dragged these cases out, and in a situation where the child is in pain, this only prolongs their suffering. During the dispute, the current status continues, essentially placing the child's treatment at a standstill when their condition may be fluid, as indeed happened with Charlie Gard. He continued to degenerate. Secondly, not only is the child detrimented, but the impact on the parents, the healthcare practitioners, and their relationship cannot be underestimated. Charlie Gard's parents described it as completely and utterly daunting and terrifying to go to court. Both sides received abuse, death threats, even in the streets, online, and Great Ormond Street had to call in the police, which impacted further on the care that they were providing for their patients. The adversarial nature of the dispute, when taken into the court setting, forces the doctors and parents against each other when they're supposed to be working together to do what's best for the child. This can only widen gaps of opinion between the two, destroy the trust between them, which can be highly problematic in examples where they require further care, such as palliative care decisions that were taken for Charlie Gard. Finally, because the courts must be transparent, this takes the dispute over the care of the child into the public domain, particularly in the recent cases where the parents waived their right to anonymity. This seems entirely inappropriate for such a sensitive and personal issue. The case comes under public scrutiny, where the public will form opinions, take sides, and sensationalise the issues, which is demonstrated by the language and virility that was used to describe the doctors. This not only further increases the void that is now developed between healthcare professionals and the parents, but also makes it difficult for the judge to give an independent ruling free of public influence. Cases such as these therefore not only damage the specific relationships at play, but also public trust and confidence in healthcare professionals at large. All this is caused by having to apply the best interest test to cases such as these. The court setting and what is entailed through the best interest test is divisive, unhelpful, and ultimately not in anyone's interests. Where therefore can we go to reform the best interest test? Relationships between doctors and parents do not usually break down to this extent. The issue at stake is often communication, where parents do not feel listened to or fully understood, and where the doctors are perceived to be the enemy. But both parties clearly have the interests of the child at heart. The answer is therefore to utilise the commitment of the sides to engage in proper joint decision-making. In an era of collaborative medicine, the court setting is by no means collaborative. Instead, a process based on building consensus and mediation between the parties to move to an agreement is likely to give the best outcome for the child. This is what we recommend to reform the test: mediation, conciliation, and consensus building between parties, in-house rather than by referral to the court. This will avoid the problems of the court setting, ensuring proper communications between parties and bringing them together, not forcing them apart. Charlie Gard's parents have even proposed Charlie's Law to make mediation mandatory due to their experiences with the court. Rather than being restrained by the confines of a legal test, a flexibility can be adopted to suit the individual nature of each case. Should mediation fail, instead of defaulting to the courts, we propose an ethics committee review the case and reach a decision. This could comprise healthcare professionals, lay people, and even bioethicists to represent all views fully and make a truly holistic decision which is not confined by the requirements of a legal test.
Is it working? Oh, it is. Oh, good. So my name is Nick, and I am an honours student at the University of Strathclyde. So I'm just going to attempt to rebut a couple of the points made by the Edinburgh team. Okay, so it's oftentimes argued in quite a sensationalised manner that our current legislative position on best interests is too paternalistic and unacceptably restrictive of parental autonomy. However, we argue that, on the contrary, the best interest test serves a vital function that must be maintained. Firstly, should we remove the principle altogether? We potentially allow for parents to interpret their best interest, their child's best interest, as they see fit, and decisions may be made on behalf of a child which are truly not in their best interest. Parents may make medical decisions for their child for a variety of reasons, and of course most strive to do so with their best interests at heart. However, it's perhaps idealistic to assume that all parents truly act in their child's best medical interests at all times. For example, some parents may propose a course of medical treatment which is unreasonably burdensome upon a child, as was decided in the case of Charlie Gard. On the flip side, due to their own personal or moral convictions, a parent may seek to prevent a child from receiving medical treatment which is vital to their best interests. Such cases are known to occur. The recent case of a child exemplifies this. The case involved a mother who wished for her sick child to be allowed to die, while the doctors argued that she had not yet come to the end of her life and sought to continue her care. Alternatively, what if it's the two parents who can't come to a consensus on the child's best medical interests? Under all of these circumstances, it's vital that the court is able to assume its role not of an overly paternalistic meddler, but on the contrary, a neutral arbiter which evaluates rationally what is truly in the best interests of the child. We must, of course, respect parental autonomy and the right of everyone to freedom of conscience, but it surely cannot follow that we should do so to a point where we potentially risk allowing for the personal or moral convictions of parents to positively harm a child who does not have values or personal convictions that can contribute towards an assessment of best interests. It cannot follow either that despite children's interests being so embroiled with that of their parents, that a child's bodily autonomy is to be regarded as simply an extension of their parents' autonomy. Removing this principle removes the opportunity for doctors to challenge these decisions in each of the aforementioned scenarios, and fundamentally to lend a voice to the child who lacks the capacity to speak for themselves. The test's vagueness, on the contrary, does not provoke inconsistency of outcome. Its vagueness is a virtue, as opposed to something which causes inconsistency of outcome. Such medically complex cases need to be evaluated on a case-by-case basis by invoking a spectrum of ideas that we would consider compatible with a child's best interests. Other models of dispute resolution which involve consensus building are also too problematic to be introduced. How can we realistically expect to achieve consensus between two distraught parents and doctors where there will undoubtedly be a vast disparity in medical knowledge and also their emotional states? And crucially, how can we expect to achieve consensus when there has already been ample opportunity to build consensus consistently throughout the process, and this has obviously failed up until a point where the relationship of trust and confidence between the parents and the doctors has broken down so irretrievably that a judicial remedy is regarded as the only option. Moreover, having their decision-making challenged by a doctor or team of doctors, parents would be totally unlikely to want to sit across the table from those doctors who have a differing opinion on what is in the best interest of their child. We therefore need a parallel process, which is the best interest test. Consensus is not an alternative legal test. We need a test which sets some kind of standard for the court to judge by and which also achieves a decisive outcome. In fact, all models don't work. Other models, such as the frequently proposed introduction of a significant harm threshold, that's equally problematic. The word harm in itself implies that when the threshold comes into play, the parents are accused of positively harming their child. It could therefore stigmatise the parents, instill fear within them, and cause them to be less open with doctors about their child's case. The significant harm threshold would also shift hospitals away from their core purpose, the care of its patients, towards child protection. As others highlight, rightfully, it could also turn an inquisitorial process where everyone is working together to assist the court in its task of identifying where the child's best interests lie into an adversarial contest to be won. This cannot be acceptable. The best interest test for these reasons must not be reformed. While imperfect, it fulfills a vital function that must be maintained.
My name is Soumya. I'm a visiting student from America. I study at the University of Glasgow. I'm completing a biochemistry degree. We'll be going to medical school in America in the fall. The opposing team has contended that the current best interest test fails to account for familial interests. This is simply not the case. Parents have more investment and are impacted by what will happen to their child. However, this is no reason to give parents more of a say in their child's life. Parents have made every decision for their child from birth until they are of legal age, and they already have a lot of impact in their child's welfare. We acknowledge and concede that one cannot separate the interests of their parents from their child. The interests of the parents are the interests of the child, as their lives are bound up and intertwined. But the rights of the parents should not be considered while evaluating the best interests of the child. Parental rights can only become limited if a third party can prove that the parents are not acting in the best interest of the child. Otherwise, it is quite irrelevant for the rights of the parents to come into question when they're determining the best interest of the child, unless they are maleficent. Presumably, another function of the test is to uphold the conscience rights of doctors who feel that a course of medical treatment is truly not in the best interest of the child. We also need to balance familial interests with physician interests who have a duty to do no harm. The digital era has allowed medical knowledge to become freely accessible through platforms such as WebMD or PubMed. Increased availability to complex medical knowledge has allowed the general public to become cognizant of the power of doctors and reject the notion that the doctors know best. Both the judiciary and the public have felt increasingly empowered to challenge the medical opinion of the healthcare sector. In such a climate, judges have become more inclined to side with the views of the parent rather than the physicians when considering the best interest of the child. The complex medical cases of Charlie Gardner, Alfie Evans would not have come to court had it not been for familial rights and intervention. As such, familial rights are a decisive factor in the judgment of the best interest of the child. The interests of the child are increasingly difficult to disentangle from the familial interests. Especially in the end-of-life decisions, the best interest and the quality of the life of the child can be interpreted in the context of family. The judiciary is put in a precarious position to decide when to intervene on behalf of the child. If they are too laissez-faire, they are seen as spineless and ineffective, while the sense of over-intervention can incite a view that the government is overly paternalistic and authoritarian in its approach to policymaking. Regardless of what the courts do, they are painted in an unattractive light by sensational media, causing their public opinion to suffer. Our opponents note that the current system is costly, time-ineffective, and authoritarian. The evidence here did not prove this. Judicial reliance is neither unduly paternalistic, nor is it expensive or time-consuming. Jonathan Herring, an academic legal commentator, has pointed out, the law makes no attempt to ensure that everything that adults do in relation to their children on a day-to-day basis promotes their welfare. Even in life-and-death situations, there is usually minimal supervision by the courts. In most cases, parents can make decisions for whatever reasons they deem appropriate, often with medical advice but without court interference. Only a tiny number of cases are referred to the courts. The advantage of the current best interest test is that the court attempts to reach an objective, balanced view using the available evidence to determine what course of action would serve a particular child's interest. The best interest test is therefore attractive and useful. Lastly, the opposing team posits that the public setting is inappropriate to the subject matter. There is no doubt that the privacy of a child, or any other person for that matter, should be protected, and their intimate details should not be paraded across the judiciary. The medical, legal, and ethical development of healthcare law relies on the setting precedents for what we believe to be morally and ethically reprehensible. Through public opinion, we are able to ask ourselves meaningful, reflective, introspective questions that help us form intersectional ideology that we incorporate into societal norms and values. After all, if it were not for the highly publicized cases of Charlie Gard and Alfie Evans, we would not be here debating if the best interest test should be reformed. Actions are expressive. They carry meaning. This is true for nearly everything we do, from the most mundane to the most significant tasks. The societal meanings of actions can also be set for the law. Laws have an expressive function. Many people support law because of the statements made by the law, and disagreements about law are frequently debates over the expressive content of the law. So we must ask ourselves, what do we want the expressive function of the law regarding the best interests of the children? Do we want the current law that reflects the best interests of the child to be of paramount consideration? Or do we want a reformed law that may fail to protect children who have no meaningful way of advocating for themselves?
Hello again. The Glasgow team submit that the best interest test, while certainly not without its issues, must not be reformed. Firstly, as we'll hear from Sumya in a second, where this principle is engaged, which despite representations to the contrary within current bioethical discourse is not very often, it's typically done so under impossibly emotional circumstances, where it's perfectly understandable that all reason goes out of the window. Yes, there are indeed circumstances under which the test is engaged that are not so serious, but its vital function is fundamentally the role it plays in serious and medically complex cases. These are the cases in which a neutral and rational arbiter is most needed. The recent and tragic case of Charlie Gard serves as an important reminder of this and of the test's vital function. As Sumya will explain, Charlie in particular had a highly complex neurological disorder and tragically had little brain function and quality of life. He spent a large proportion of his short life tied to machines, breathing artificially and being poked and prodded by doctors, who eventually concluded that continuing to ventilate was unreasonably burdensome upon him and that treatment should be withdrawn, as this was ultimately not in his best interests. His parents disagreed. They wanted to take him abroad for experimental treatment, which had no conclusive evidence of any effectiveness. The doctors engaged the best interest principle, and it was decided that despite the parents' best intentions, continuing medical treatment was not in his best interest. Hopefully none of us within this room can empathise with or possibly comprehend the impossible circumstances under which Charlie's parents found themselves. However, if we could attempt to for a moment, I am sure that we could all agree that making rational choices while grappling with such an insurmountable amount of grief would be a tremendously impossible task. Furthermore, understanding and fully appreciating complex medical conditions such as Charlie's is something which the reasonable person would struggle with, let alone two grieving parents. The court must therefore continue to evaluate rationally and on an evidential basis, taking into account the medical complexities of each individual case, such as Charlie's, if the treatment proposed is truly in the best interests of the child. Therein lies the fundamental role of the best interest test, not an overly paternalistic mechanism which is unacceptably obstructive of parental autonomy, but on the contrary, a neutral arbiter which intervenes under impossible medical circumstances in order to ensure an outcome that is truly within the best interest of the child is achieved. We also argue that parental autonomy cannot be limitless. It would perhaps also be idealistic to assume that all parents make decisions which are truly in the best interests of their children. Parents may opt to continue or withdraw from a particular course of medical treatment for a variety of personal or moral reasons, and there simply must be a legal test which places checks on this and sets a normative standard of acceptability. The best interest test must therefore continue to operate in order to allow doctors to intervene under circumstances where parents make decisions which genuinely are not in the best interests of their children or which could positively harm their child. We will also hear from Melissa in more detail that we have a balanced and fair approach as it stands, one which represents in equal measure both general interests and medical best interests. Should we remove this mechanism and replace it with something else, we risk eliminating the court's ability to ensure children are always protected. We also argue that there is no other way of resolving such matters which is viable and does not entail immense issues of practicality. For example, alternative forms of dispute resolution or thresholds such as significant harm, a proposal which is currently at the forefront of bioethical discussion, hinder rather than help matters. The word harm in itself risks stigmatising parents and discouraging them from speaking openly with doctors about their child's medical care, for fear they will be accused of positively harming their child. This completely undermines the doctor-patient relationship, as does the inevitable process of doctors and nurses within a hospital having to prepare a case against parents. This would likely eliminate all possibility of any form of mediation being successful in the early stages. We also turn an inquisitorial process, as I said previously, where everyone is united in determining the best interests of a child into an adversarial contest to be won. This just can't work. For these reasons, the Glasgow team submits that while not perfect, the best interest test should not be reformed in the interest of the medical welfare of all children.
The British Medical Association Code of Ethics and DPA laws dictate that the duty of healthcare professionals lies in upholding the autonomy of patient, protecting confidentiality, and acting in the beneficence of the patients. These laws clearly state that the physician has a duty of honest and truthful disclosure of the diagnoses. In situations where a patient is unable to consent, decision-making authority is delegated to the family, who act in the understanding the best interest of the patient. Above all, we must understand the physician's duty to veracity. Veracity is the tenet that one should tell the truth, and honesty is the best policy. For a patient to make an informed and rational decision, all facts of the case must be presented in an accessible manner to the patient to ensure that their understanding of the prognosis is easy and comprehensible. If the patient is not told appropriately of their condition and treatment options, it can affect their autonomy because their liberty of action and respect is undermined. Moreover, the physician's ability to abide to the beneficence of their patient is compromised because they no longer can help their patient's interests by upholding autonomy. In the case of Charlie Gard and Alfie Evans, both patients lack the capacity to consent because of their age and their condition. In that case, when a minor cannot consent to treatment, it is usually the parents who make the medical decisions. The healthcare team will continue to advocate for the autonomy of the minor by repeatedly sharing relevant information to the parents, setting important information in perspective, and modulating tone in response to the psychological state of the parent. However, parental competence can be called into question if they're making a difficult medical decision under emotional duress. Parents are in a precarious position to make a rational decision when they're under traumatic stress because of physical and cognitive constraints. They might undermine the well-being or best interests of their children through compromising effects such as an inability to understand the diagnosis or treatment, fear and depression, societal constraints, and expectations. However, when a medical professional and parents disagree about a course of treatment or the care plan, we go to a neutral arbiter to reconcile the two sides with independent judgment and objective judgment of the child's interests. The court often faces the difficult decision of negotiating between two disparate interests while staying on the side of the law. Situations may be legal while being morally and ethically irresponsible, and in such cases it is difficult to prioritize each facet in order to reach a decision. If you consider Charlie Gard, we understand that he was suffering from a fatal and rare inherited disease called MDDS. While Charlie was not brain dead, he did not exhibit normal signs of brain activity such as crying, response to stimuli, or interaction with surroundings. The medical experts were in agreement that there was no chance of recovery and Charlie did not derive any benefit from continued life. However, Charlie's parents accepted and understood that his quality of life was poor and not worth sustaining, but disagreed with the assessment of the healthcare team. They wished to take Charlie to the United States for experimental treatment that had not undergone animal testing and focused on a different strain of MDDS. It is no doubt that Charlie's parents were under immense stress, which could have affected their ability to make a rational decision. We are not saying that Charlie's parents did not understand what the healthcare team were saying. As with any parents, they were so overcome with grief and stress that they held on to any hope, however tenuous it may seem. Understanding the intricacies of disease pathology to an appreciable degree in normal circumstances is difficult. let alone in situations where human life is in hand. Therefore, there are laws such as the current best interest test that protects parents and from making difficult medical decisions that they make in not a proper emotional state and may regret in the future. Charlie's parents should not have been in the position to consent to their child's life and death situation. It is not only unfair but also cruel to the parents to be put in this position. This is why we have mechanisms in place to protect parents from themselves during the bereavement process. The current best interest test places the crucial decision of making difficult medical decisions in the hands of the court if the parents and clinicians disagree. The court takes into account multiple perspectives when assessing the welfare of the child, since there is no law that can provide an accurate determination of a child's best interest. The system gathers all evidence independently, avoids bias, and provides the best recommendation for the child's welfare. We must make a rational, evidence-based recommendation and decision that ensures the child's best interest is prioritized. We must remember at the end of the day, the prima facie of law is to preserve the sanctity of human life, liberty, and agency.
Hi, I'm Melissa and I'm an LLB student at the University of Strathclyde. There is already the presumption that parents will make the best decisions for their children and that parents should be the most involved in decision making about their child. They're of course the ones who are most affected and are most invested in the welfare of their child. At present, this only gets disturbed if there is real concern on the part of some other party that the child's best interest might be compromised. Parents rightly have the most say, but this cannot be limitless and to the extent that there are no checks in place for the child. This therefore means that we need some sort of legal test, and this essentially boils down to either the best interest test, as we currently have, or the significant harm test. This, as we have noted, would raise the threshold for judicial interference to the much higher standard of significant harm. We contend that the best interest test should therefore be retained, as the significant harm test, as the most likely alternative, raises serious problems. Firstly, significant harm essentially asks doctors to perform a dual role. Doctors are taught to do no harm. Are we to ask them to cause harm until it reaches a level that we deem significant? This is a worrying thought. A doctor's instincts are to consider their patient's best interests. Significant harm is just not natural and doesn't fit with this. Secondly, the best interest test and the significant harm test are balancing tests. The only question is where the balance tips, and crucially where we want it to tip. Would we really feel comfortable allowing harm until it reaches what we deem significant? If the significant harm test were introduced into children's medical treatment decisions, this could also be dangerous for parents. If there are already concerns about whether a child's parenting is good enough, then any failure to accept medical advice will slot into the existing significant harm case building exercise. If there are not already concerns, there might well be afterwards, since a court determination that parental decision making may have caused significant harm would put that child on a local authority's radar. It's not difficult to see how a significant harm test for decisions about children's medical treatment could have a chilling effect. Responsible, loving and well-intentioned parents might well be deterred from holding out for what they believe to be in their child's best interests if they feared that in doing so, they risked having their child taken into care. It is also likely that significant harm would actually end up being interpreted as we currently interpret the best interest test. Ultimately, if we didn't downgrade it, then we are setting a child protection threshold. If we do lower the threshold, we turn it back into the best interest test. It's often assumed that best interest means purely medical interest. However, the current test allows consideration of the fact that the child's interests require more than purely medical considerations. A child's interests are of course intertwined with their parents, and it's right that parents are given the strongest power in relation to their child. Therefore, subjecting parents to the worry of the consequences of the significant harm test is unfair. Furthermore, the current test, as advocated by Lady Hale, allows a subjective evaluation of the patient's wider social and welfare preferences, and this is where the input of parents is crucial. They know their child best, and they hold the crucial information on what is in their best interests. Any legal test which might deter parents from inputting fully should not be championed. Along with this, the best interest test is protective.
It means that for a severely ill child, no one will be allowed to refuse treatment that could benefit them, or, even if motivated entirely by love, force health professionals to provide prolonged, unpleasant medical treatment that cannot help them. The original intent of the best interest test was to protect children from abusive or neglectful parenting, and this remains an important reason for it. Sadly, there will be a small percentage of children where the test is needed for this reason. Therefore, we contend that it is without question that we need checks in place, and this essentially means that we need a legal test. For the protection of both parents and children, the best interest test as it currently stands should be retained.
Hi again. I'm going to address a few points that my opponents made. Firstly, dealing with the issue of consensus. We've heard it argued that it's not going to be possible to build consensus between doctors and the parents. First, I'd like to restate that it is a communication issue that we see often here. There's nothing to suggest that consensus couldn't be reached between the two sides. Indeed, if it wasn't possible, why would Charlie Gard's parents be proposing that this is something that should be used? Clearly, it is possible to reach a consensus over cases such as these, where the issues are properly discussed, both perspectives, the doctors and the parents, are put forward in a conciliatory way, and full consideration can be given to both sides of the argument and agree together what an approach would be. Equally, why we propose the Ethics Review Board instead of the court setting is to allow situations where consensus cannot be reached to be then reasonably considered by a separate body. The problem with the legal test in this instance is that the judge is only one individual. They, therefore, are the only person in the situation that has to make the determination. An ethics board gives a much more holistic approach. It allows for various opinions to be taken into consideration. It allows for various points of view to be put forward in regards to deciding what is best for the child. The problem with the judiciary is highlighted if you even look at the makeup of most of the senior judges that we see in the UK. They come from similar demographics, they come from similar ethnic backgrounds, and indeed the gender split is not even either. In this instance, therefore, the biases of the judge, even those that they don't themselves fully understand, can still come out and impact on the decision that is made over the child. Therefore, equally, it may be a legal test, but the fact that the judge can make decisions on what they believe to be relevant will mean that it is in fact a determination that comes down to one individual, which is not appropriate. We believe that the problem with the best interest test is that the parents' views are not given proper place. This is not about allowing the parents to run wild and make any decision over the child that they should be allowed, even if people think that it's wrong. This is about looking at the parents' opinions as part of the wider picture. Our opponents have said clearly that this is about ensuring autonomy. Well, in situations such as this, surely a relational model of autonomy would be much stronger, given that the child is indeed highly embedded in the family relationship. The interests of the child cannot be separated from their family surroundings, those who care for them, and the opinions of those around them, and those need to be given proper place. Our opponents have also said that mediation would potentially put the parties against each other. I would like to clearly point out that the current test already does this, and equally the current test will undermine the relationship between doctors and patients. Equally, the test may discourage people from coming to court. For example, the Aisha King case, where the parents abducted their child and took them abroad because they didn't agree with what the doctors were going to do. This is not a legislative test either, as it is for adults. It is a test based on precedent, which is fluid and constantly evolving, which lacks consistency. There is not always a connection between the law, between ethics, and between the outcomes of what should happen. And it is naive to suggest that, in fact, the law will always give the best ethical outcome. Finally, clearly, this is a highly emotional and difficult situation for all parties to be in. Emotional situations do not give themselves over to rational outcomes well at all. Our opponents are suggesting that a rational response to an emotional issue is appropriate. I would not agree with this at all. The emotional issues require flexible and compassionate approaches to allow for the full scope of the issues to be properly considered, rather than a rational legal response. What we are proposing instead is a compassionate system that allows the parties to get together. Mediation is already built into the NHS. It is used all the time to resolve disputes, not only between doctors and those they are treating, but also between parties within the NHS, colleagues that do not disagree with each other. This system could easily be adapted to encompass what we are proposing. Equally, the judge could take their proper place in this as well. An ethics review board, as a public body, would be subject to judicial review, but this would give the position of the court to be the arbiter of the decision making rather than the decision maker, and this is far more appropriate.
Hello, I'm Juliana Gleeson and I'm also in the Medical and Ethics in the University of Edinburgh. Amidst denials of paternalism coming from our opposition, the best interest test has been justified on grounds that the parents lack the ability to comprehend the condition of their child. This in fact smacks of paternalism and is an entirely unacceptable justification of the best interest test in the era of collaborative and autonomous decision making that we find ourselves. The social and familial embeddedness of the child has been extensively repeated by both ourselves and the opposition. Parents are, by the nature of their relationship with their child, considered to be always acting in the best interest of their child and should have the autonomy to do so. This fact has been acknowledged by our opposition, and it has been acknowledged that this is not interfered with in general day-to-day life and general day-to-day decisions. Why then should the situation be different now? We question where the consistency is between this statement and a road in this context that leads directly to a court decision which is built on intervention. Given the normative and indeed legal value attached to autonomy, it has long been accepted that the existence of capacity to act in this manner is to be presumed. The Mental Capacity Act in this jurisdiction itself is designed to protect and restore power to those vulnerable people who lack capacity and not to take it away. The United Nations Convention on the Rights of Persons with Disability, under Article 12, advocates for a total end to substituted decision-making in favour of supported decision-making. The case of Recy and Montgomery established that not understanding has been eradicated as a viable reason for deciding to act on behalf of or instead of a person. Unwise decisions are not to be disregarded on this basis. By the reasoning suggested by our opposition, are we to believe that where adults lack understanding, the correct approach is an automatic deferral to a court setting? No. In fact, society and law demand the contrary. Education and support in understanding is legally required for adults, with autonomy as the starting point. The best interest test, when justified on the basis of a parent's inability to understand, failed to provide similar support. By failing to support the parents, ultimately, we fail to support the child. There is no justifiable reasons for autonomous principles to be different, even if, as the opposition have suggested, the numbers are low. In addition, the parents of Charlie Gard, by refusing mediation in favour of court proceedings, are a testament to the prima facie attractiveness of legal proceedings, where ultimately a winner can triumph. This attractiveness usurps the parents' and indeed doctors' willingness to understand. By removing the court setting and replacing the ultimate goal of winning with the goal of understanding, the issues identified are most constructively sidestepped. It cannot be ignored that a justification of this kind serves only to fuel our identified discomfort with complete neglect of parental insight, and instead deference to medical opinion bought by the best interest test. It has already been shown that an approach of this manner undermines a holistic understanding of what is of benefit to the child. Suggesting that the matter be brought to court, thus usurping their autonomous power, is entirely contrary to established medical legal principles and must not be tolerated. Encouraging, therefore, their continued involvement, their continued understanding and engagement is the best way forward. A court setting is not conducive to support of this kind. The best method is to ensure out-of-court resolution. Finally, in response to contentions that there is a need for a limit to the parental will of parents involved in these situations, there is not and never has been a right to request or demand any kind of treatment. Removal of this kind of situation from court will not see the medical system play into the hands of parents involved in undoubtedly tragic situations. Checks, for policy reasons, for lack of resource reasons and more, do not wholly rely on a court setting. Mediation has extensively been identified as a more appropriate course of dealing with these situations and suggesting that it is not because parents will run wild in terms of their requirements is in fact just ill-founded.
Okay, as you have seen, there are numerous issues with the best interest test that prove that it's not fit for purpose and it needs to be reformed. In terms of its practical application, the inherently subjective nature of the test creates issues in consistency and predictability. It leaves the test vulnerable to judicial bias. This is demonstrated by similar cases having opposite outcomes, as Iman referenced, and ultimately the outcome turns on the judge's interpretation of which factors are relevant. The judicial reliance on medical opinion is, as we've said, unduly paternalistic. It reduces the child's best interests to their medical interests. And this takes us back to the archaic doctor knows best narrative, which is inappropriate for the current era. The best interest test also fails to appreciate the child as embedded within social and familial relationships, and it underplays the importance of those family interests. The individualistic nature of the test undermines all that it purports to consider, such as the religious and the cultural values of the family and the child, the views of the parents, and those close to the child. In terms of setting, the court system is completely inadequate to solve the problem of what is best for the child. And the entire setup of the best interest test, it needs to be changed. In the design, the best interest test is idealistic, but in its application, it's failing. When the test is applied, the child becomes a point of law. The two sides that should be working together to reach consensus are pitted against one another, and the public nature of the court setting sensationalizes the dispute, and is therefore detrimental to the interests of all parties involved. In terms of arguments that the other side has put forward, parents actually are best placed to make decisions for their children. In all other cases, we assume that they are the ones who are best placed to make those decisions. And keeping in mind too, the best interest test is not just about best medical interests. And so a consensus building model would allow a more holistic approach to understanding the intricacies of family and individual values. On the argument that parents won't be able to understand the child's condition, so they shouldn't be making decisions about treatment, to that we say that more work needs to be done to facilitate understanding and communication between parents and healthcare practitioners through things like supported decision-making, further education, understanding. This is all important for parental autonomy and ultimately what's in the child's best interest. In response to the argument that we can't expect parents to make these difficult situations in such emotional times, I think it's important that we don't discount the importance of emotion in these types of decisions. The importance of emotion and family values. The problem with the best interest test is that it's designed to create a rational response to a highly emotional and relationally complex situation. The current law is a blunt tool for resolving these types of issues, and it just isn't fit for purpose. So this is why we recommend our alternate model based on consensus building, which places due importance on the role of emotion and relationships in complex decision making. This will be a more flexible and compassionate system. And I mean, this type of decision making is supported by the Mental Capacity Act. So that's designed to protect and restore power to those who are lacking capacity for various reasons, rather than take it away. And lastly, I guess when the other side said that there need to be checks and balances in place so that parents don't run wild, we don't need a best interest test to establish this. Currently, parents can't request medical treatment that's not available. So I think, again, a model of consensus building is more appropriate in this sense. I think overall, hopefully, we've been able to show that the best interest test is not fit for purpose, needs to be reformed. Instead of employing a set test to determine the course of treatment for the child, which again drags the parties through the court system and brings their personal and relationally complex issues into the public sphere, the compassionate thing to do is to move towards a model based on consensus building, cooperation, dialogue, and only by moving away from the best interest test based on legal principles towards an approach based on collaborative medicine and family empowerment can we ensure that outcomes are truly what's best for the child and truly what's in their interests.
Tonight, we have been arguing for the best interest test to be kept as it stands. The current test has been described as the gold standard by the President of the Supreme Court. We therefore feel that a compelling alternative would be needed in order to depart from the current test. Crucially, we must remember that even with all the focus and attention on the test has had from the recent high-profile cases of Charlie Gard and Alfie Evans, the courts have so far shown no willingness to depart from it. I will now seek to summarise our points and demonstrate why we feel the test is fit for purpose and does not need to be reformed. We must remember that cases which reach the stage of going to court, and particularly those which come to be in the public sphere, are rare, and this is a last resort for both parents and medical professionals. We must remember that in the majority of cases, the treatment path of a child will already be an ongoing conversation and will be decided and developed without any mention of having to go to court. Therefore, the best interest test and involvement of the court is reserved for a minority. Furthermore, we must appreciate the intense emotional suffering of the child's parents. We are asking parents to make informed medical decisions based on complex conditions while they are dealing with intense stress and grief. The best interest test, as it is, allows the opinions of parents and doctors to be balanced with the aim of reaching the best outcome. In all of this discussion, we must know that we are often having to make decisions and give opinions based on unknowns. The outcome of treatment and the effect of treatment on individuals can be assessed and reasoned, but is never certain. The pain and suffering of a child can be assessed, but again can never be accurately measured. Therefore, it's again important that we have a balancing test. There are some points we must consider. Our first argument for the retention of the current test is simple. We need an actual legal test. When a case reaches the point of having to be settled through a court action, the relationship between the parties has already broken down irretrievably. This means the hope of them being able to use other methods of conflict resolution is limited. The parties have already been engaged in dialogues with each other, perhaps spanning many weeks and months, trying to build consensus on their own, and they have now reached an impasse. At this stage, with two parties so opposed on such an emotional issue, referring the decision to the court is necessary to move things forward. We also feel that asking parents to sit across a table when their child's life may be at stake Expecting them to resolve their differing and opposing opinions is unfair. Consensus building is not an alternative to a legal test, as it might not work. As we have in other areas of law, we need an endpoint where, when all other routes have been unsuccessful, we have a way of definitely reaching a decision. This is what the current test offers, and we therefore feel it would not be appropriate to substitute the current test for other forms of dispute resolution where there is a chance that no decision will be reached. Secondly, we must remember that at the heart of this case is a child who is severely ill. First and foremostly, it's unfair and even cruel to leave this child who may be suffering while those who care for them, both parents and the doctors, are trapped in a dispute without any hope of resolving it. It's clear we need a neutral arbiter to step in so that a decision can be reached. The current test has been criticised as being too vague. We fully agree that the test is vague, however we contend that this is actually a huge positive. When we're dealing with situations as difficult as these, it would be ultimately wrong to have a test which is so clear-cut and defined that it does not allow scope for consideration of the intricacies and details of each case. We should be pleased that a child's best interest will be determined not from a tick-box list or predetermined set of responses, but that we have created the facility for the judiciary to evaluate each case fully and reach an assessment of best interest for that child in a sensitive and thoughtful way, and crucially on an individual basis. While cases may appear to be similar and have differing outcomes, they are never identical. Our argument for the retention of the current test rests on the basis that the only alternative would be the significant harm test. As we have outlined, we feel this test creates many problems for the child and the parents. It's difficult to imagine that we would allow harm to a child until it reaches a level deemed to be significant. How significant is significant, and how much harm could we cause? Parents should of course have the most important say in their child's treatment, and they should be free to voice their opinions and wishes without fear that their input could lead to child protection measures being invoked. The significant harm test raises the problem of steering hospitals away from their core purpose, the care of its patients, towards child protection. It would also stigmatise parents. It's bad enough to have a court find that what you wanted for your child was not in their best interests, but it's much worse to have a court find that you may have caused your child significant harm. If the concept of significant harm was imported into specific medical treatment decisions, parents who dare to disagree with doctors stand to lose not just control over a single medical decision in their child's life, but quite possibly their child. The best interest test was established to prevent abuse and neglectful parenting, and we contend that this remains an important reason for having the test as it currently stands. While in the cases of Charlie Gard and Alfie Evans, the parents had flawlessly good intentions. Sadly, this is not always the case, and a minority of children may be at risk from abusive and neglectful decision making. The test as it currently stands means that children with parents who are not so good intentioned are protected from abusive and neglectful decision making on their parents' part, whether that's through withholding of potentially life-saving treatment or the provision of treatment that will only cause more harm and suffering. Furthermore, we need a test that allows consideration of a child's welfare in the widest possible sense. A child's best interests are intertwined with that of their parents, and we need the involvement of parents in order to assess best interests in a way that encompasses medical interests, but also social and other general welfare considerations. The crux of the argument for us is therefore that in order to achieve the best outcome for a child, the only conceivable alternative would be the significant harm test. This was cited in literature surrounding the cases of Charlie and Alfie. However, we contend that for the reasons outlined, this raises more problems, and we would rather have a test which allowed parents to be fully involved and free to voice their opinions without fear of consequences of disagreeing with the child's doctors.
Before I make some commendations to those who have spoken this evening, I thought it might just be useful to make a couple of very brief, I promise brief, comments and observations of my own here. These are the most difficult of cases, which makes healthcare and medical law such a wonderful subject to study. It brings the most basic instincts of emotion and passion to the fore in an attempt to try and find a resolution. Our colleagues here have already spoken about the challenges inherent in best interests, significant harm, or indeed the very forceful arguments that Charlie's parents tried to put forward, saying that they were not causing harm, therefore please may they be allowed to have taken their child to America for treatment. They argued very forcefully for the primacy, and something that perhaps wasn't mentioned as much tonight, the idea of the violation of their human rights as parents to be the final arbiters in a decision about their child. Domestic courts in the United Kingdom and elsewhere have a wide margin of appreciation in cases that do raise these most sensitive moral and ethical issues. It was acknowledged by the European Court of Human Rights when they considered this case that the UK court and Judge Francis had beneficial and direct contact with all parties to this case, the technical expertise, the medical expertise, the understanding of the technicalities of the illness that Charlie had. It was very forcefully and eloquently alluded to the trial by public opinion that this case already brought forward, and there'll be very few of us that don't still carry imagery of protests outside the court, or an image of a small soft toy that Charlie's dad carried with him during every public appearance. What then of mediation and the idea of being able to sit down, medical professions, those who can explain the technicalities, and the families involved? Most powerful arguments were brought forward, including the acknowledgement that whilst this mediation is occurring, this leaves the child perhaps in some form of stasis until some way forward can be found. Turning to our colleagues, fantastic speaking, passionate speaking, and team working, which, given the pressures of time that are incumbent upon all of you, were evident throughout. Particular praise goes to those who had to conclude the arguments, and for that I thank you. Very, very well done indeed. At the end of the day, there was nothing really in terms of your styles of presentation. We're all quite different, so it left me to try and make a decision on the part of the law. And whilst I would love the idea of communication and sitting down and trying to work this out, the one thing that persuaded me from the Glasgow City colleagues was the idea of an end point. An end point I couldn't see in this idea of mediation and communication. And in fact, in the Guard case, that had been offered. There was about to be an opportunity for ethical discussion with the ethics team. And unfortunately, Charlie's condition deteriorated and he was fitting almost constantly for a period of 10 to 12 days. And that moved the arguments and moved the urgency again. So perhaps it would be fair for me to say that perhaps we will move to this at some point, this idea of mediation and sitting down and finding a way to be able to go forward with that. But in the meantime, flawed though it may be, I'm going to award the argument to the Glasgow City team this evening for defending, albeit what may be a flawed best interest test, as being perhaps currently the best that we have in Scotland just now. Thank you very much.
Thank you so much, Alison, for that fantastic judgment, and thank you again to the team. Well done to both teams, and particularly to Glasgow there for your winning the judges, swaying the judge. In terms of the public vote, we started off with, in terms of the question, should the best interest test be reformed? We started off with 22 people saying yes and 19 people saying no. And by the end of the debate, we had 14 people saying yes and 28 people saying no. The numbers don't add up, by the way. But it gives you a view. I think that's really what tonight was about. It was about airing the issues in this incredibly difficult area of medical law, which I think the teams both did absolutely fantastically. There's one final thing for me to attend to. If I could ask my beautiful assistant to give a small token of our gratitude to Alison for her work tonight, and also to Mary Neal, who has done so much to make this